And here comes the defendant, Ross Harris. He's in court. The judge is on the bench. The lawyers are there. Let's go in.
Here on General Bill Indictment 14-93124, and the right of the measures to suppress that have been specially set. The first matter are the Rule 22s, and I have them from the following outlets: NBC, CBS, WXIA, and Fox. Any objections from the state
We have no objection, we defer to the court.
and from the defendant?
Your Honor, we continue to raise the objection we raised previously about the matters.
That will be noted for the record. I'll sign them over those objections. All right. Are we ready to go forward?
State's ready.
We're ready to proceed, Your Honor.
You're going to argue for the defense, Mr. Walsh?
I am, Your Honor.
Very good. Please proceed, sir.
Could we, before we get started, if we, as the court has done previously, allow Mr. Harris to have his right hand released so that he can make notes, communicate with us?
I think we've done that before. I know that you filed an amended consolidated motion today.
I am not, Your Honor.
Oh, okay. All right. It was filed December the 4th. We're in good shape.
If I have filed one, that's probably a very good one, Judge, that's.
I'm sure it'll be excellent.
Thank you.
On the other hand,
On the other hand, Judge, just very briefly, just to give you an outline of where we're going here.
thank you.
The issue before the court is going to be the multiple searches and seizures that the state has executed upon Mr. Harris's property, that including items at his home, items in his car, items at his work, and potentially other items in other locations related thereto. Basically, Judge, what we're asking the court to look at here is to answer some very basic questions of what the Constitution protects any citizen here in our country against an unreasonable search and seizure without proper warrant. As the court looks into this evidence, you're going to hear, hopefully in chronological order as the investigation took place. I anticipate that's probably how the state will put up their evidence and how we will address it as well. Regarding the seizure initially from Mr. Harris of his cell phone, and then subsequent searching of that device, and then subsequently searching through his vehicle, through his home, through his work, through other locations involved with his work, excuse me, separate from his actual office. And basically, Judge, what we're asking the court to do is simply follow the law, that there's a requirement that in order for the state to seize a person and or a person's property and to search a person's property, that they follow the basic requirements, that they show that there is a valid warrant or there's some explanation and some legally justifiable excuse for not having a valid warrant. Specifically, we have in excess of 30 search warrants that were issued in this case. Because of that, this is a very tedious process in some extent, but I hope it's going to be a very interesting process for the court and for the parties as we look and see exactly what the state did and maybe more importantly what the state did not do in proceeding in these searches and seizures. I'm going to ask the court to answer the basic questions of, was there actual probable cause provided to a magistrate in order to allow issuance of search warrants? In providing that information, the court would also want to answer the question, was there misleading on behalf of the state in order to attempt to provide probable cause? The court will want to answer the question, why are there multiple times in which the state's not even attempting to provide probable cause to explain how there is any belief whatsoever that there would be evidence of the alleged crime to be located anywhere other than the instant location of the scene where this occurred? And is there any probable cause, or why is there no even attempt to provide probable cause to explain why there's believed to be certain items of evidence to be located in particular places? The state has the burden upon it in order to show that there was probable cause to believe there was other evidence, that there was evidence to be located in a particular place, that they actually provided that information to the magistrate, that they did not mislead the magistrate by material misrepresentations or by material omissions. And in the process of executing these warrants, how did they go about executing the search warrants? Even if they were valid, did they limit their execution of the search warrants to the specifics authorization of each search warrant? What we anticipate showing from the evidence, Judge, is that multiple people took part in these searches and seizures, specifically as it involves these electronic devices. This is a growing area of the law, and so Your Honor has a great opportunity, frankly, to make what I believe is a historical decision, good or bad. Unfortunately, me and the courts who have looked at this in the past have made decisions which continue to prove to be in error in allowing the state wide latitude in its securing and searching and seizing of devices without sufficient probable cause, and also allowing them to search those items well beyond the actual probable cause that may have been provided in those limited cases. As the courts are continuing to enforce the Constitution and make very clear that citizens do have rights against the state that will be enforced against unreasonable search and seizure, we're going to ask the court, when it's all said and done, to simply follow the law as we have it, as it's being shown to us by our Supreme Court, that in fact we're going to protect citizens over protecting the state. That's what we're asking the court to do, is look at this evidence, make a determination as to exactly, has the state met its burden? Have they done even the minimal requirements in order to go searching into another person's life and livelihood? As far as the actual evidence, Judge, I anticipate we'll have some witnesses, first of all, regarding the seizure of a phone from Mr. Harris, a chain of custody of how that phone got from him into police custody and ultimately how they searched it. I believe we'll have evidence of them executing multiple search warrants, again, in multiple locations. And so we'll hear from, there's predominantly one detective who was responsible for securing most of these search warrants. I believe Detective Stoddard also secured a few of these as well. Detective Murphy, who's the one who's responsible for the majority of these. We'll be hearing from them very specifically as to what information he had and he gave to the magistrate in order to obtain a search warrant. We'll then be hearing from at least one, I presume multiple persons who actually did forensic analysis of these electronic devices to try to explain to the court how in fact they went about doing that searching, and were they limited in any way by either the search warrant, by the detectives, or by their own understanding of how these electronic devices work, to limit a search to only what was being sought. At the end of the day, Your Honor, we're going to argue to the court, of course, what the law is, but I think the evidence will show is that they well exceeded, if any of these warrants even had sufficient probable cause, they well exceeded any probable cause in their searching because they simply wanted to look at Mr. Harris's life. They wanted to just go on a fishing expedition to see what they could find. And in essence, that's what produces evidence that the state now has before it. The Constitution says that's improper. The United States Supreme Court says that it's improper. Our Georgia Supreme Court says that it's improper. We believe Your Honor will say that's improper. That's why we're asking the court to sift through this evidence. We appreciate the patience the court will have. This is as I said, because of the nature of what we're dealing with, it is a lot of technical information. In order to make the record very clear, we will have lots of questions to make it as clear as possible exactly what we're dealing with. And at the end of the day, or at the end of the next 2 days, or if it takes a little bit longer, we'll put together how the law affects those facts and ask the court to, in fact, grant this motion to suppress, which is a consolidated motion considering each of these search warrants. Thank you, Your Honor.
Thank you very much.
Your Honor, I too will give a brief opening statement to the court and sort of outline how I anticipate we'll present evidence in support of the denial of defendant's motion to suppress that has been filed. I will point out to the court that police responded, as you've already heard, in this particular case to this crime scene on June the 18th of 2014. We've already done a Jackson Deno hearing, so you've already heard a lot of evidence pertaining to that initial scene response by Cobb County Police Department. Eventually, the defendant was arrested that same date after making some spontaneous non-custodial statements during his brief detention, and he also made some Mirandized statements to police. That's of note in this particular case because those statements in large part supported the basis for the issuing of certain search warrants that are at issue in this particular case. I will point out chronologically that this defendant was indicted on September the 4th of 2014. You've correctly noted that a general motion to suppress was initially filed. I have a dated copy here. The date on it is October the 27th of 2014, and it's a 3-page document filed by Mr. Kilgore. 10 days ago, defendants supplemented their motion with this consolidated motion to suppress. We received that filed in our office on December the 4th of 2015, so just 10 days prior to the start of the motions today. That motion is pretty extensive. It's about, 30 pages it looks like, maybe a little bit longer. Of note, certain issues are raised, admittedly. Also of note, certain issues are not raised. So, there is some law and authority that we'll be getting into about particularity and those types of things as we get to that point in the conclusion of this hearing, whenever that may be. So, the defendant having filed this motion to suppress, this additional consolidated motion, they are seeking to have this court suppress a number of items of evidence and find that searches and seizures regarding primarily electronic devices, a defendant's home, a vehicle, his workspace and work computers, they're asking that you find that these are unlawful under the Fourth Amendment. Here's the chronology that I hope to establish for the court with several witnesses. I expect to call the initial responding officer who you've already heard from, Detective Piper, who was a uniformed police officer at that time. As you may recall, defendant was on the phone when she arrived on scene. He was non-compliant with them, said some derogatory things, cursed at them when she asked that he get off of the phone. Based on his non-compliance, as you may recall from the Jackson Deno, he was briefly detained. She at that time took possession of his phone that he was using to obstruct her ability to figure out what was going on in this death investigation. At that time, no search was conducted on the phone. She merely maintained the phone until such time as defendant could be transported to Cobb County Police Department, where he could sit down with Detective Phil Stoddard, who's seated behind me, for his custodial interview. At that time, cuffs were removed from the defendant. He was informed of his Miranda rights. You've already made a ruling as to that. Defendant was interviewed and gave some assertions about this case that were of note and evidentiary significance to detectives. Based on that, Detective Stoddard tasked Detective Murphy with assisting with this investigation. Information was relayed to Detective Murphy that formed the basis of the first sort of round of search warrants that were issued in this particular case. Those search warrants were issued on June the 18th and June the 19th of 2014, and they included searches of the defendant's home, searches of his vehicle, searches of certain devices that were recovered, including this cell phone that had been previously taken by Piper and turned over to Detective Stoddard. Before any extensive search could be conducted on these items, additional evidence was discovered independently of any search. This independent evidence came in the form of evidence of extramarital affairs that the defendant had essentially denied by claiming that he had a good relationship with his wife. Based on that and other information that was obtained during this investigation, after just a cursory search of the cell phone and messaging that was conducted by police just to kind of find out a timeline and chronology leading up to the death of Cooper Harris. After that, additional search warrants were sought and obtained that were admittedly more detailed and expanded the scope of the permissible search, having now learned about certain evidence that was important to police in terms of motive. So these additional search warrants were issued on or about June the 24th and June the 27th of 2014. Again, before any full extensive search of electronic devices had been done, only a cursory search of defendant's cell phone had really been done at that point. Some of the devices had admittedly been dumped, is the word we use, and that the stuff had been extracted from the devices, but no extensive search had occurred then. Thereafter, the full analysis of the devices began, including the full analysis of defendant's cell phone pursuant to these two batteries of search warrants, the initial search warrants that were issued on the 18th and 19th, followed by the more extensive scope search warrants that were issued June 24th and June 27th. These first series of search warrants were all obtained by Detective Murphy, so I expect that he'll be on the stand to authenticate these search warrants and his testimony that was provided to successive magistrate court judges as he obtained these. Looking at the search warrants alone, I believe the court will see that there was ample probable cause to support the issuing of the search warrants. Nonetheless, I do expect to put on evidence of additional oral testimony that was provided by Detective Murphy to the magistrate court judges that issued these search warrants on the 18th, 19th, 24th, and 27th. Additional search warrants were obtained by Detective Stoddard in August of 2014, I believe. There was also some additional search warrants that were issued in 2015. These three search warrants were obtained by Detective Stoddard, again, product of having more information as the investigation unfolded into the death of Cooper Harris at the hands of the defendant. You'll see that each successive search warrants became more detailed, and while most of them focused on devices that had already been seized from the outset on June the 18th and June 19th, the reason for the successive search warrants, you'll see, is it expanded the scope of the permissible search of these items as we began looking more into motive that the defendant had for this particular murder case. Some of the search warrants were for evidence that, quite frankly, were items that the defendant has no standing in, so that'll be one of the issues we'll be raising. For example, there was a search warrant that was issued for a Lenovo that belonged to Home Depot. It was admittedly found in defendant's vehicle, but that was not his property. It belonged to Home Depot. Similarly, there's some Home Depot records. I note in the defendant's motion, I didn't see any motion to suppress dealing with medical records, but I do expect to put on some evidence of that as well. There were some medical records that were obtained from third parties. Obviously, defendant wouldn't have any standing, we would suggest to the court, for these types of records and documents, them not being in the possession of the defendant. So that's one of the issues we'll be focusing on as well. I'll go ahead and tell the court one of the motions that was filed was for a device that we weren't terribly familiar with. It's a Google Chromecast device. We thought at the time that maybe that was some sort of device that had storage capabilities. It turns out it does not. So I'm going to touch on that very briefly, but for at least one of those search warrants, you'll see that there was nothing obtained and therefore nothing to suppress. So I'll just go ahead and tell you that at the outset. We weren't terribly sure what that was at the initial obtaining of the search warrants. We now realize that that was basically an internet router and it doesn't appear to have any storage capability. So we expect to essentially go chronological with how we present the evidence, starting with Detective Piper to talk about her initial detention of defendant and the initial warrantless seizure of his cell phone, which you'll see under the case law is authorized. We do expect to present evidence by way of certified copies of the search warrants in question. I will tell the court that I have packaged together the discs of the recorded testimony of the detective, particularly Detective Murphy, to the magistrate court. I'm going to make that a part of the record. I obviously will be referencing that in questioning. I do not expect to play those discs for the court, but they will be available should the defense wish to play those. I'll probably tender those en masse. They are packaged according to magistrate, because you'll see that the magistrate judges, as they were issuing these search warrants, were listening to the testimony as a whole and then ruling on the search warrants sort of en masse as detectives were seeking them in sort of a lump sum. So that's the evidence I expect to present to the court. Obviously, the law is going to be pretty important in this case, and we brought quite a bit of law that we need to share with the court. Some of the issues raised that the defense has put in their lengthy motion to suppress include warrantless seizure of the cell phone. I will be focusing in part on consent evidence. There's some suggestion that the evidence sought in this case was outside the scope of a permissible search warrant. We'll be addressing that as well. The defense has suggested that there are material misstatements. We disagree. At best, there are inaccuracies. I'm not even sure that we could call them inaccuracies when you look at the totality of the circumstances of the search warrants. The scope argument is raised in defendant's motion, so I expect there'll be questions about scope of searches. Particularity is raised, sufficiency of PC is raised. I've already mentioned to the court that there will be some evidence that we'll need to present regarding standing for some of the items. And then I expect that there's also going to be some evidence involving inevitable discovery as well that will be raised in this particular case. So that's chronologically how we expect to present the evidence in this case, Judge. And we think we have several witnesses that will establish fully that this was perfectly permissible from the outset up until today. The issuance of the search warrants, the searches that were conducted, and the minimally intrusive searches into defendant's items based on the evolving information that was received by detectives during the course of their investigation of this murder.
Let's proceed with evidence, please.
Call Detective Piper.
Once she's coming, Judge, if I could just place a matter on the record, just so it's clear before I forget. We have been receiving discovery from the state in an ongoing nature. Some of that is very recent in time, so we just want the court to be clear. We want to preserve our right to file additional motions, and in fact, we find there's additional information we've been provided. And preparing for this, obviously, we've not had time to go through additional things that have just been given to us. Hopefully there won't be any, but we'll just let the court know. Obviously, that happens, we'll bring it to the court's attention. We're hopeful to address each of these matters as we outlined in our motion today.
Well, that's fine, but I'm not going to give you a carte blanche ability to file motions untimely. You'll have to justify it factually. And I want to remind everybody, we have a special set trial. So we don't need delays. We follow our timeline that's been established. It's reasonable, it's doable, and I expect that we will do that. So just want to make that clear. But certainly if you find yourself in that position and you can justify it factually, then we'll proceed when that happens, if it happens.
Thank you.
Your witness. If you'll stand and be sworn.
Richard. You solemnly swear affirm the testimony you shall give to the court on this nothing but the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Excellent.
All right, once you're comfortable, if you'll just adjust that microphone. And I know the court's already heard from you, but for our record, if you will state your first and last name, spell it for our court order.
I'm Detective Jacqueline Piper. First name is spelled Jacqueulyn. Piper, Piper.
You are currently employed with Cobb County Police Department, correct?
I am.
Current assignment is detective.
Correct.
And prior to that, did you have any uniform responsibilities?
I did.
This court already heard from you regarding the Jackson Deno issue, in other words, the motion to suppress defendant's statements. I want to talk to you a little bit about your involvement in this case from a search and seizure perspective. Were you one of the responding officers to the scene at Acres Mill on June 18th of 2014?
I was.
And for the record and the court's benefit, if you could just give us a short chronology of how it is that you came to respond to that scene.
On that day, I was eating lunch at Shane's on Cobb Parkway. I heard Officer Gallimore put out radio traffic about a child not breathing. From there, I left the business, responded to my patrol car, and arrived on the scene there.
And where specifically was that scene?
Matteo's, Acres Mill, and Cobb Parkway.
And you were one of the first responding officers, is that correct?
I was.
And why don't you describe what it is that you saw in terms of the defendant when you first arrived on that scene?
When I parked my car, I could see the defendant walking back and forth. He was on his phone screaming. From there, I went over to the first officers, Officer Folia and Officer Gallimore, to see if they needed any assistance there. I talked to a security guard, asked him to assist us in backing the crowd up. Then I went to the defendant. I asked him for his ID. Officer Folia told him to get off his phone. That's where he cursed at her, and we had to detain him in handcuffs.
At that point in time, when you first responded to the scene, where was the decedent, Cooper Harris?
He was on the driver's side of the defendant's vehicle.
Okay. And had you had an opportunity to actually see Cooper Harris prior to having his initial conversation with the defendant?
No, I could not see him.
You were aware of the nature of the dispatch, though, is that correct?
I did.
Okay. Now, you described the defendant pacing around. What kind of, did he have an iPhone that he was holding at that time?
He did.
Were you actually present when Officer Fogley informed him that he needed to get off the phone so that we can figure out what was going on?
I was.
And for the record, I know it involves a curse word, but what did the defendant say at that time?
He told her to shut the fuck up.
And based on that, what action do you and the other officers take to continue the investigation into the death of Cooper Harris?
At that point, we put him in handcuffs. He began to slide his phone into his pocket, and I took that from him.
And why at that point did you detain the defendant and take his phone?
Multiple reasons. First reason being that he was hindering our investigation with that cell phone. We asked him to get off the phone. He, at that point, moved forward towards Officer Folia in a threatening manner. Also, we take the phone just so once I place him in the back of my car, I'm responsible for everything that goes in that back seat. So that includes removing a phone that he could access to call other people to the scene.
Okay. Was there an officer safety component to taking that phone as well as the obstruction that you mentioned?
There was.
And when you initially began detaining the defendant to put cuffs on him, what was he resistant?
He was. He was pulling away.
And were you successful in getting the cuffs on him?
We were.
And once you took that actual phone after he tried to slip it in his pocket, what specifically did you do with it?
I immediately gave it to Sergeant Thorpe, who was also on scene.
And he's one of your supervisors, is that correct?
That is correct.
Now, at this point in the investigation, did you know whether anyone else other than the defendant might have been involved in this death investigation?
I had no idea.
And at this point, did you know whether any arrest was going to be made involved in the death of Cooper Harris?
I did not.
What was your limited role as the responding officer in this particular investigation?
My role was to simply secure the scene, whether that's through crowd control, in this case, securing the defendant for detectives and transport.
At some point, were you actually the officer that was tasked with transporting the defendant?
I was.
Describe to the court how it is that you transported him and where specifically you took him.
The defendant was in the backseat of the patrol car, secured in handcuffs. I drove him from the incident location to our COB headquarters, which is located at 140 North Marietta Parkway.
Had you not initially taken that cell phone from him when he was detained, in other words, had he slipped it in his pocket, would you allow him to keep that phone during transportation?
I would not.
Can you please explain to the court why it is that you would not, as a matter of course, and in this specific instance, allow the defendant to have his cell phone for transportation?
It's due to cell phone capabilities. You can text, you can send emails, you can make phone calls. In transport, obviously, you don't want the defendant texting people where he is. It could set up an officer safety issue either for an ambush, and it could also, not that I was aware at this time, but you could destroy evidence that way.
And could having that cell phone on him while in transport impact the investigation?
It could.
Have you specifically, in your personal experience, had any situation where that has occurred when a defendant's in the back of a patrol car with a cell phone?
I object unless it's something prior to this incident that had no relevancy and it's happened afterwards because it didn't play a role in her making a decision on that day.
Your argument.
With the defense challenging the reasonableness, if there are anecdotal evidence of situations that this officer is personally familiar with where cell phones been used to obstruct an investigation, I think it's fair for the court to judge your reasonableness of the seizure based on that.
I'm allowed over objection, but I think it's valid to take the timeline into account in evaluating the relevance of the testimony.
Do you need me to repeat the question? Do you understand what I was asking about prior situations where a cell phone has been used while in the back of your patrol vehicle?
I understand.
Can you please explain to the court whether you had any prior situations where this indeed occurred?
Prior experience through training, I've had more senior officers tell me to look out for if defendants are on their phones, either through traffic stops. It's simply because we've had it before where they've called people to the scene, whether it's they know they're about to go to jail, so they'll call someone there to pick up their car. if they think it might extend further than the car to their homes, they'll have drug evidence removed and such as that.
In this particular case, the cell phone that you initially took from defendant, did you do any search of it?
I did not.
Did you power it on and look on it or anything like that?
Absolutely not.
Once you gave it to Sergeant Thorpe, did you come into possession of it any further, or was that turned over to Detective Stoddard?
I never had any further contact with that phone once I gave it to Sergeant Thorpe.
Having talked with the defendant briefly on scene, did you become familiar with his voice?
I did.
I want to ask you a little bit about post-transport. Post-transport to headquarters, can you please describe what, if anything, you did as part of this investigation?
Anytime I have someone in my vehicle, I'll change the camera view. There's a camera that's located inside the patrol cars that will face typically towards the road to capture any kind of movement by vehicles. Once I had that person in my car, I switched the camera view to face him to show that there's not been any sort of abuse or if he tries to harm himself in that car.
Once the defendant was transported to headquarters, you're aware that the cuffs were removed from him for an interview, is that correct?
That is correct.
And did you have any further action on the case in terms of the 911 call review?
Once I was there, I have experience with 911. I did that for 2 years. I knew that it would be helpful to the investigators if I went upstairs and picked up any 911 tapes if they were available.
And for our record, the 911 call center happens to be at the same location where you transported the defendant, the Crimes Against Persons Unit. They're in the same building, correct?
That is correct.
So what specifically did you do in terms of going to get the 911 calls pertinent to this case?
I went upstairs. I talked with the dispatcher, who was Debbie. She said that she also took that 911 call. She played it back for me. I recognized the caller to be the manager at Matteo's. And then from there, I obtained a copy of that audio from the 911 supervisor.
Having gone to the 911 center, did you confirm that, having listened to the defendant's voice in your interactions with him, that he was not the 911 caller in this case?
He was not.
And had he made any statements to you about who he might have been talking to on the phone prior to your release of him to Detective Stoddard?
He did not.
When you listened to the 911 call, did you confirm that he had not called 911?
I did.
And with that information, what did you do with the disc and what you had learned from the 911 dispatcher? Who did you share that with?
I shared that with Detective Stoddard. I provided him with the CD of the audio, and I believe it was either the day after or 2 days after I confirmed it with the manager of Matteo's, and that he did make that 911 call.
Speaking to the manager of Matteo's, did you recognize that voice as being the same voice you heard on the 911 call?
I did.
And did you actually transport defendant's phone that you initially took off of him to police, or was that Thorpe that turned that over to Detective Stoddard?
I believe it was Sergeant Thorpe that turned that over to Detective Stoddard.
And what were the reasons that you took that phone initially from the defendant and gave it to Thorpe?
Removing the property, I think we've covered that, but I just simply gave it to Thorpe, so, it wasn't any danger of getting damaged.
And had the defendant been using that phone in any way to hamper your ability to investigate the death of Cooper Harris?
He had been.
Can you explain for the court for our record?
With him being on the phone, I asked him for his ID. From there, that's when he became confrontational with Officer Folia. He was using that device as part of that obstruction. Once the device was removed from him, his noncompliance ceased.
I think that's all I have.
Cross-examine, please.
Thank you, Your Honor. Is it Detective Piper? Is that the proper title?
Yes, sir.
Thank you. Detective Piper, I have just a few questions for you. Anything you're not able to understand is unclear, certainly just let me know. My southern drawl sometimes is missed on some folks.
Thank you.
How long have you been a police officer?
At that point in time or now?
Well, at that point in time would be great.
I believe at that point it was 2 years.
And was that entirely here with Cobb County?
It has been.
And was that as a, what we refer to as a road officer at that point in time, uniformed officer?
That's correct.
Now, as you came to the scene, Officer Folio was already present on the scene prior to you, is that correct?
That's correct.
And remind me, is that a male or a female?
Female.
And was she engaged in speaking with Mr. Harris at the time that you got there?
No, she was not. She became engaged when I asked him for his ID and he didn't comply.
Right. And so when you got there, you said you did not see Cooper Harris yourself initially, correct?
To clarify a little bit, when I pulled up, Officer Foley and Gallimore were standing by the child. I could not see him from there. Once I exited my patrol car, I did not speak with the defendant. I went right over to the officers to see if they needed assistance. That's when I saw Cooper, and then I spoke to the security guard and then the defendant.
And you keep referring to the defendant. Just so we're clear, there was no defendant on the scene at the time that you got there, correct?
That's correct.
All right. You're just there to try to figure out what's going on.
Yes, sir.
You've not made any assumptions or conclusions about who's what at that point in time, correct?
Correct.
All right. And as you saw Mr. Harris, he was on the phone acting erratically, I think is the term we've heard before. Is that fair characterization?
Yes, sir.
And in speaking with someone on the phone in that condition, then Officer Folio went over to him to try to speak to him while he was on the phone. Is that correct?
That is correct.
All right. And Mr. Harris indicated, I think he pointed out very clearly, even using some strong language, his desire to stay on the phone to talk to whoever's on the other end, correct?
Correct.
And at no point in time did Mr. Harris take the phone and attempt to hit Officer Foley with it, correct?
That's correct.
And at no time did he attempt to use the phone as a weapon against you, correct?
Correct. It's not a felony obstruction.
Very good. And there's no indication that he used his phone as a weapon against anybody on the scene, correct?
Correct.
He was simply talking on it in an erratic fashion.
That is correct.
And then as Officer Foley asking for some information, you were there present, I take it nearby when that was going on as well.
That is correct.
And at what point in time did you ask for his ID?
I asked for the ID that started the interaction between myself and your client.
And was he still on the phone at the time you were trying to talk to him?
That is correct.
And did he say anything to you to try to get you to leave him alone at that point in time?
No, he simply motioned with his hands to hold on.
All right. And how did you respond to that?
I didn't respond to him directly. It was Officer Folia who asked him to get off the phone.
And at that point in time, was that when he got off the phone?
He did not get off the phone himself. That's when he stepped forward towards her, small officer, and from there we had to detain him.
And when you say he stepped towards her, how close was Officer Folia to him when she was trying to talk to him while he was on the phone?
Once he stepped forward, I would say with arm's distance,
Okay, 3 feet?
approximately.
And he stepped forward to her. Is that when he said the bad word to her, for lack of a better term?
That's correct.
And at that point in time, is that when you detained him?
That is correct.
And so when you detained him, did you have the phone up to his ear?
No, we grabbed his arms, and that's when he put it behind his back and attempted to put it in his pocket.
And you're saying that he was not able to get it into his pocket?
He was beginning to slide it, and that's when I took it from him.
You recall testifying previously in this case at a prior hearing, correct?
I do.
And at that point in time, you were asked very specifically where his phone was when he was handcuffed. Do you recall that?
I do.
And at that point, you given it Sergeant Thorpe by the time he was handcuffed. Is that correct?
That is correct.
And when you went to handcuff him, you recall being asked where was his phone at the time you handcuffed him, and you responded it was in his back pocket. You recall that?
I do.
All right. So is it clear that he actually had put his phone in his pocket before y'all even got to the point of handcuffing him?
To be more specific, I guess I can. He began sliding into his pocket. It was not fully seated just yet before I removed it.
Well, what does that mean, fully seated?
Like it wasn't sitting in his pocket just yet. As he began to slide it, that's when I removed it from his pocket.
So you're saying it wasn't inside of his pocket as you justified previously?
Partially.
Did you measure it by chance?
No, sir.
In any event, it's clear that he was not coming at anyone with the phone. In fact, had gotten off the phone call and was putting the phone away, correct?
When he was
When you took
on, correct.
And was it at that point in time that you decided you were going to handcuff him and keep him in your patrol car?
Correct.
You had no thought of trying to talk to this man who's in a highly stressed state, just kind of figure out who he is and what he's got to do with this whole investigation?
Based on his previous actions, the best decision at that point was to go ahead and move him to a secluded spot where he wouldn't draw further attention to the scene, which would create further problems for responding officers.
His previous actions being talking on a cell phone legally,
Screaming on his cell phone, pacing back and forth, moving to a location where he wouldn't have the ability to pace around, and we would be able to control his actions.
at the point in time that you decided to put your hands on him, he was not screaming at anyone at that point in time, correct?
He calmed down.
He calmed down. He put his phone at some length in his back pocket and was no longer coming at anyone, saying anything, expletive fashion, yelling, screaming, anything of that nature, correct?
He had calmed down, correct.
Did you pat him down for any weapons at that point in time because you were concerned for your safety?
I do not recall.
Well, before you put him in your patrol car, would that not only be something you would do is pat someone down for weapons?
It would be.
But you don't know if you did in this case.
I think we may have, I don't recall.
Is it possible that you didn't because at this point in time, he was not a defendant. He was not under arrest in your mind, correct?
Correct.
And as regards transporting someone, do you normally try to determine what items they may have in their pockets and what not? As you've indicated previously, that you want to make sure there's no other dangerous instrumentalities or items in their possession at that point.
Correct.
Do you recall there being other items that Mr. Harris had in his pockets?
At the time, I don't, but I think he did have a wallet in his back right pocket.
You did not take that from him?
I did not.
Do you know anybody took it from him before you transported him?
I don't remember if anyone did.
Is it in the same pocket where the cell phone was?
It was not. That pocket was empty.
When you handcuffed him, did you handcuff him with his hands in front or behind him?
Per our policy, it's behind.
Now, after you put him in the patrol car, did you then continue to speak to him or did you go up to the other officers?
I spoke with him, and I was getting basic administrative answers, his name, date of birth, and whatnot.
And he was speaking with you calmly at that point in time?
He was.
So whatever your role in the investigation at that point in time, he was in fact assisting with that, correct?
Correct.
And at any point in time after you handcuffed him, did he come at you, reach for something, indicate any sort of threat to you?
He did not.
Did you put handcuffs on yourself?
We used 2 sets of handcuffs. That was between myself and Officer Folia.
And did you put one of those sets of handcuffs on him?
Yes.
Okay. Officer Foley is assisting you, I take it?
Yes, sir.
All right. And you said he was pulling away. Was he trying to run away from you?
He was not running away, but he did pull his left arm from me. At that point, I did advise him to stop resisting, and he complied.
When you say he pulled his left arm away, tell us what you mean by that.
I'm not quite sure how more specific you want me to be. He was pulling it away from myself.
Did he pull his arm out and wave it around and was trying to get away from you, or did he just move his arm a little bit because it was hard to get his arms behind his back?
I had to use force to pull his arm back.
Okay. So you were having difficulty getting his arm behind his back.
Correct.
And was Mr. Harris's size one of the reasons that y'all used 2 sets of handcuffs?
That's correct.
All right. And that's because of someone of a larger size than Mr. Harris was, it's harder to get your hands back there to get them together to handcuff them, correct?
Correct. We didn't want to harm him.
After you got him handcuffed, were you concerned that the handcuffs were going to fall off of him?
No.
Okay. And did you have his hands handcuffed behind his back such that he could pull out a phone and make a text or an email or something behind his back?
Had he had a phone, he would have been able to.
And can you explain to us how he would be able to do that with his hands behind his back and his phone behind him?
Do you want me to demonstrate?
Is that something that you're normally used to doing? Texting people with their phone behind your back?
No, I'm not handcuffed, but I have seen it done before.
All right. And have you seen anything about Mr. Harris that indicated to you that, one, he had any desire to do that, or two, he had any ability to do that?
Well, from speaking to him, it was important that his wife be contacted. So had he had his phone, I would believe that he would have made an attempt to do so.
Right. What he wanted to do was make sure his wife was contacted and know what was going on here. That's what he was upset about, correct?
Correct.
All right. And did you indicate to him that you were going to contact his wife to make sure she knew what was going on?
I did not.
And as far as you've indicated some concern about destroying evidence, again, we're very early on into the scene as you're dealing with Ms. Harris, correct?
That is correct.
And as far as evidence goes, you didn't have any indication there was any evidence on that phone whatsoever regarding what you'd been called there for, which was a child in distress or deceased, correct?
That's correct.
And you talked about sometimes there's drug evidence that may be removed from phones, possibly in drug investigations. There's nothing about this that indicates this is a drug investigation, correct?
That is correct.
When you took his phone, where did you put it?
I gave it to Sergeant Thorpe.
Was he standing right there beside you?
He was standing in front of me.
Okay. So you just simply took it and handed it to him in one single motion?
Yes, sir.
Did you happen to see what Officer Thorpe did with the phone?
I do not recall.
You indicated when you got the 911 calls that you recognized the manager by his voice. Excuse me. Are you familiar with that person prior to this incident?
I was.
And as far as the searching of 911 calls, did you do the search for the 911 calls yourself, or did you simply ask someone at the 911 call center to provide you with this call?
I asked someone that was at the 911 center.
So as far as any other calls that may have been to 911, you're simply aware of what they provided to you, correct?
Correct.
whether or not there were other calls made or not, you didn't have that knowledge at the time, correct?
I did.
Did you get other 911 calls as well?
That was the only call related to that incident.
Those provided to you, or did you do some further investigation?
Those were provided to me.
So at the point in time that Mr. Harris is handcuffed in the patrol car, he's compliant, answering questions, calm down, and allowing you to do your job, correct?
That is correct.
Okay, just a minute, Judge. With regards to you were dealing with Mr. Harris at that point in time, you were getting information in your investigation simply to figure out who he was and what any connection he might have to the scene, correct?
That's correct.
He was not under arrest at that point in time, correct?
That is correct.
He was not being charged with anything at that point in time, correct?
Correct.
And he was fully cooperative with you, correct?
At that point, correct.
Very briefly, just in regards to the last point, who in this investigation would be responsible for charging decisions, if any?
That would be the Crimes Against Persons Unit.
Specifically Detective Stoddard and his team, is that correct?
That is correct.
You had talked about the defendant having his hands handcuffed behind his back. Had he had his phone on him at that time, would he have been able to retrieve it from his pocket?
Objection, Your Honor, that calls for speculation.
State the question.
Could the defendant reach his pocket with his hands handcuffed behind the back?
She can testify to that.
Yes, especially reviewing video, the defendant was able to completely turn his body from the front of my vehicle and look out the rear of my car.
You had mentioned on cross-examination seeing an instance where a person was able to access their phone even though they were handcuffed. Can you share more on that?
Yes, there was vehicles located at Cumberland Mall that had been involved in an armed robbery. I was working a part-time that day. I responded. 4 subjects were taken into custody one by one. I remember the subject that I detained had a cell phone in his pocket, and due to the numbers of the arrestees on scene, we quickly placed him in a patrol car to detain everyone and make sure we limited the number of subjects outside our patrol cars and obviously limit their escape routes. Once that was all done, I went back to the subject that I had detained, and he had his cell phone out to his side and he was texting.
Okay. And were his hands similarly handcuffed behind his back per department policy?
They were. In fact, only one set of cuffs had been used in that case.
With 2 sets of handcuffs, does that extend the length of the handcuffs?
It does.
Can you just explain to the court, I think it's code for the record, but were both handcuffs on the defendant in that he had 2 cuffs per wrist, or what did you mean for our record?
2 sets of handcuffs. I can demonstrate. They're the hinge cuffs like you see here. When you use 2 of these, this length doubles in size.
What you did is you linked the 2 sets together to extend them to be essentially double the size of the linked cuffs.
Correct.
You had mentioned the possibility of, for instance, drug evidence being removed or altered on a phone. Could other evidence be altered on a phone if it is left in a perpetrator or defendant's possession?
Absolutely.
The defense had asked you about the defendant's demeanor after you seized the phone and detained him. Did he become compliant prior to you taking the phone from him?
No.
Was he compliant prior to you putting handcuffs on him?
He was not.
There was also a question about the defendant having a wallet. I think you said it was in a different pocket. What items was the defendant using to obstruct your initial ability to assess the scene other than the cell phone?
Nothing else.
So just the cell phone was being used as an instrumentality.
Correct.
Now, you mentioned also on cross-examination that the defendant told you that he wanted to contact his wife. Is that accurate?
That is correct.
Did you know who he was talking to at the time of your arrival on his phone?
I did not.
Based on that question, did you surmise that it wasn't his wife?
Correct.
At that point in the investigation, did you have any knowledge whether or not the defendant, Ross Harris's wife, may or may not have been involved in the case?
I did not.
All right, thank you.
Ted Piper, do you treat suspects in armed robberies differently than normal everyday citizens that you encounter as a police officer?
Absolutely.
And because when someone's a suspect in a crime, especially a violent crime of that nature, your senses are heightened as to your safety because they've already, at least to your knowledge, indicated a safety risk to others, correct?
Correct.
And in this case, there had not been any call to a violent crime, correct?
Correct.
There was not any indication of any weapon on the scene, correct?
Correct.
The simple thing that happened is a common citizen stepped forward while he was on the phone telling the officer that he was wanting to stay on the phone, correct?
The way I would describe it is we have an officer who's under 5 feet tall. She asked him to get off his phone, and anytime we see a subject who towers over one of our officers step forward and tell her to shut the fuck up, we're going to respond appropriately to make sure it doesn't become a violent confrontation.
Is it fair to say you just didn't like the language he was using?
Absolutely not. Had he just said that and he brought his tone down, there was a chance that he would not have been put in handcuffs. We continued the investigation from there. The step forward towards an officer indicates that there could be a violent action.
And the point of fact is, once you stepped forward, in fact, he did lower his tone, he did get off the phone, he did put it in his pocket before you decided to handcuff him, correct?
The moment we put hands on him, that's when he brought down his tone and began to put his phone in his back pocket. So his actions were a result of ours.
I understand. In fact, put it in his back pocket, correct?
Began to, correct.
Well, did he put it in his back pocket or not?
He did.
He did. Very good. So at that point in time, he was calmed down, listening off the phone, correct?
Correct.
But nevertheless, you decided to go a step further and put him in handcuffs.
That is correct.
As you're on the scene and as you transported Mr. Harris, you're still not considering him as being under arrest, correct?
That is correct.
Did you consider at any point in time of taking the handcuffs off of him just so he could be more comfortable so y'all can get to the station and see what's going on?
We don't do that during transport.
Okay. Even to someone that it's clear has not committed a crime?
It's a safety issue. Your client is much larger than I. If situations changed, he would have access to, let's say, a window that's open. He could unlock the door.
Are the back doors of Cobb County police officers' vehicles ever be unlocked from inside?
They're not.
But he was not yelling and screaming, kicking out doors, kicking out windows, anything of that nature as he sat in your patrol car, correct?
That is correct.
And as far as you mentioned his wallet, do you remember him having a wallet on him?
I don't recall.
Would it surprise you that he did and you allowed him to maintain that in the backseat of your patrol car?
If it was there, then I can't change that now.
I understand that. Would that be a safety concern for you?
Possibly, depending on what's in the wallet.
But you didn't even check to see if he had one as far as you recall?
No, I don't recall.
If he had been a suspect in an armed robbery, is it more likely that you would have checked everything he had in his pockets to make sure there wasn't some sort of weapon?
It's possible.
Did you ever consider allowing him to make that phone call after you spoke to him, after he was calm and compliant, explain the situation to you?
I did not, and he didn't ask again.
What do you recall asking him who he needed to call when he told you that he was wanting to call to the Little Aprons Academy to make sure they let them know what's going on before his wife got there?
I believe his statement was, I need my wife to be called. She's going to Little Apron Academy where he's not going to be. And that was the only question that he had asked.
At that point in time, did you offer to let him make that phone call or to make the phone call for him?
I did not.
Was there anything about that statement that indicated to you that your safety was in danger?
It was not.
Anything that indicated to you that any evidence was going to be tampered with or destroyed?
No.
Indicated he was obstructing with any investigation at that point in time?
No.
Thank you.
No redirect.
Can you step in?
Thank you.
Yes, please.
Call Detective Sean Murphy.
From the first witness, and this is a hearing that's going to take more than today, most likely. You heard the defense in the beginning of this saying this could be a day, 2 days, or even more. Right now we're getting ready for the second witness to take the stand. You're looking at live pictures of the defendant, Ross Harris, inside the Cobb County courtroom. Again, the big issue today is what evidence comes in, what evidence comes out. The defense wants all of the electronic evidence suppressed at trial. Let's take you back in. We'll be streaming this all day long.
Court on this, nothing but the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, once you're comfortable, why don't you adjust that microphone and let's state your full name for the record and spell that for our court reporter.
It's Sean Murphy, S-H-A-W-N, M-U-R-P-H-Y.
And where are you employed, sir?
Cobb County Police Department.
What specifically do you do with Cobb County Police Department?
I work for the Crimes Against Persons Unit.
How long have you been with the Crimes Against Persons Unit?
Almost 2 years now.
Prior to that, did you have prior service with Cobb County Police Department?
Yes, prior to that, I was employed with Cobb around 7 years.
And so you've been there 7 years total?
Almost 10 years now.
Gotcha. And what specifically do you do with the Crimes Against Persons Unit?
Crimes Against Persons, basically it investigates crimes against persons, assaults, homicides, robberies, sexual assaults, terroristic threats, things of that nature.
You mentioned homicides, so death investigation is part of your
Yes,
function and
yes it is.
responsibility. Okay. I want to talk a little bit about your role in this particular case, and let's direct your attention to June the 18th of 2014. Articulate for the court how it is you became involved in this investigation.
Well, on that date, I was riding with Detective Stoddard, and we received a phone call advising us that there was a homicide investigation in Precinct 3 at 2955 Acres Mill Road.
That's in Cobb County, correct?
Yes, sir.
And once you received information that there was a homicide investigation that needed to be conducted at that location, what, if anything, did you and Detective Stoddard do?
Me and Detective Stoddard then responded to the scene. We arrived at the location in approximately 17:07 hours on that day.
And describe the scene as you found it when you initially responded with lead investigator Detective Stoddard.
When we first arrived, there was a 2011 Hyundai Tucson parked behind Uncle Mattio's Pizza. It was kind of stopped in the middle of the parking lot. The door was open, and there was what appeared to be a small child on the ground. It was covered by a white blanket at the time with crime scene tape around it, and several pedestrians standing around the crime scene tape, and also several police officers and detectives too.
You and Detective Stoddard later identified the deceased child on scene to be Cooper Harris, is that correct?
Yes, sir.
When you initially arrived on scene, had uniformed patrol already arrived on that scene and done anything?
Yes, they had already arrived on scene, secured the scene, and they had the child's father, Justin Harris, inside of a patrol car. And I was directed to some witnesses by the officers after I had observed the scene.
And speaking to those witnesses, did you learn anything about what the defendant may have said when he initially arrived on the scene, precipitating the 911 call that came out?
Yes, the two witnesses I spoke with, they stated that they saw the vehicle pull in at a high rate of speed, come to a stop. The driver exited the vehicle, opened the rear passenger door, pulled the child out of there, began trying to do CPR on it. They said he was making statements of, "Oh my God, what have I done? My son." Once some other pedestrians came up and tried helping him out, medical, doing CPR, that type of nature, he stepped back from it and began using his cell phone.
You were able to identify the defendant as the person that was driving this vehicle and made those statements, is that correct?
Yes, sir.
All of this was prior to you leaving that scene, correct?
Yes, it was.
In addition to speaking with some of the witnesses and getting their statements, what, if anything, did you do on the scene at that time?
Besides speaking with the witnesses, took a quick look at the vehicle and just the surrounding area just to soak it in and see what the scene looked like.
And were you able to get a description of that vehicle that you later used to obtain a search warrant for?
Yes, it had a Georgia tag RT7088. It was a light blue 2011 Hyundai Tucson.
In this particular case, who was assigned as the lead detective into the death investigation of Cooper Harris?
Detective Stoddard was.
And what was your more limited role in the investigation with Detective Stoddard?
I was assigned as his second to assist him with the investigation.
For our record, what are the responsibilities of a second versus a lead investigator oftentimes?
The lead investigator is basically in charge of the investigation. The second, generally, you're there to assist with whatever he needs, because some of these investigations can be pretty complicated. Generally, that'd be getting court orders, search warrants, helping out with interviews and that type of thing.
Did you actually participate in the interview with the defendant that was conducted on June the 18th of 2014?
No, I did not.
Do you recall who did that interview?
Detective Stoddard, and I believe it's Waldorf or Waldorf.
Now, at some point, did Detective Stoddard task you with doing some things in this particular case in terms of search warrants?
Yes.
Why don't you describe for the court what it is that you were asked to do?
I was asked to obtain a search warrant for Mr. Harris's residence by Detective Stoddard.
And were you also asked to obtain a series of search warrants involving the defendant's vehicle and some electronic devices?
Yes, sir.
I want to ask you, initially, we're going to talk about the June 18th and June 19th, 2014 search warrants. You and I had a chance to review those, correct?
Yes, sir.
What initial information did you have that you used to obtain those search warrants? Can you summarize that for the court?
Basically, initially that Mr. Harris had left for work with the child. He took him to Chick-fil-A. They had breakfast, and then he went to his work instead of the daycare, forgetting to drop the child off. Went to work for the day. As he was leaving work, driving down the street, he realized the child was still in the vehicle. Pulls into Uncle Mattio's on Acres Mill Road and pulls the child from the vehicle.
You had mentioned the statements that the defendant made on
Yes.
scene. Did you include that as part of your search warrant application in your testimony to the judge?
Yes, I did. He stated, "Oh my God, what have I done?" As he was getting the child out of the vehicle.
Did Detective Stoddard and other detectives share information with you that became a part of your search warrants in this particular case?
Yes, I did.
And specifically, was information shared with you about what the defendant said during his custodial interview about having researched deaths in a hot car?
Yes, during the while I was obtaining the search warrant, the interview was going on, and I was advised, not by Detective Stoddard or anybody in the interview, but other detectives that were watching the interview, that Mr. Harris had made statements to the extent that he had recently searched through the internet child deaths inside vehicles and what temperature it occurs at, and that this was one of his biggest fears.
And you had mentioned the defendant admitting that this was one of his fears, that his child would die in a hot car. Is that correct?
Yes.
Was that information shared with the magistrate court as you attempted to get search warrants for electronic devices in particular?
Yes.
Now, in addition to the defendant's statement in this particular case, are you aware that his wife was also interviewed?
Yes, she was.
And did she disclose anything to detectives in terms of her having a similar fear involving the death of her child in a car?
Yes, the detectives that had interviewed her, I believe they went to the daycare to speak with her because that's where she was at. They said that she made similar statements that this was one of her biggest fears. They also made comments that she wasn't showing much emotion and that they were going to have her come back to the office so they could interview her at the person's office.
Was this information relayed to you as part of the process of you getting search warrants?
Yes.
I want to talk about the first series of search warrants that you obtained here. On June the 18th of 2014, did you obtain 4 search warrants from the Magistrate Court of Cobb County?
Yes, I did.
And do you recall which judge that was that you applied for those search warrants with?
It was Judge Inman. Or Mays, I'm sorry.
Okay. Judge Mays for the first 4?
Yes, first 4 was Judge Mays.
Now, in addition to, well, let's talk about the process itself. Explain for our record and for the court how it is generally that you apply for a search warrant in Cobb County.
You type up your affidavit, basically your reason for getting the search warrant, what you're looking for, the location, put together a search warrant application, and then you will present that to the judge and speak with them via a video conference.
This video conference, we call it an EWI system, is that correct?
Yes, sir.
And that's an electronic warrant interface?
Yes.
Does it work sort of like Skype?
Yes.
And in this particular case, did you indeed type up 4 search warrants on June the 18th, 2014, based on information that you knew personally and information that was relayed to you from other detectives?
Yes, sir.
And were you successful in obtaining those first 4 search warrants?
Yes, I was.
In addition to the typewritten application or affidavit and the search warrant itself, did you give sworn oral testimony to Judge Mays in support of these search warrants?
Yes, I did.
And have you had an opportunity to actually listen to the recordings of your sworn testimony to Judge Mays for the initial search warrants?
Yes, I did.
For the EWI system, does it break up the recordings by search warrant?
Yes.
Is there a way when you have the same case but multiple search warrants with multiple targets, is there a way that you specifically ask the court to incorporate all of the testimony for all of the search warrants because it's the same factual basis?
Yes, the judge or the judge you're doing the search warrants with will typically take into account the previous ones that you have done. That's how it was the first day. The second day, I had a list of search warrants I was getting, and he basically took into account the testimony for the first one with all the remaining ones after that for that day.
Okay. Let's talk about these initial search warrants from the 18th. State's Exhibit Number 1 is a certified copy of Mr. Lumpkin search warrant. I'm going to reference the last 4 numbers, so it's 0596. Looking at 0596, do you recognize this as being a certified copy of the search warrant that you initially obtained for defendant's home?
Yes, sir.
State's Exhibit Number 2, Judge Mays, same date. Do you recognize this as being a certified copy of search warrant ending 0597, also for that home, but now including electronic devices?
Yes.
State's Exhibit Number 3, certified copy of search warrant ending 0598 for vehicle. Is that correct?
Should be the vehicle. Yes, it's for the vehicle.
State's Exhibit Number 4, certified copy of search warrant ending 0599 for an iPhone that was taken from defendant. Is that accurate?
Yes, sir.
Okay. I tender states 1 through 4.
No objection.
Admitted.
In addition to the certified search warrants themselves, I have a package labeled State's Exhibit Number 5. And for our record, inside that packet, there are 4 discs. The outside of the discs have numbers 1, 2, 3, and 4. Looking at these, do you recognize these as being the 4 discs containing the recording of your sworn testimony before Judge Mays in support of States Exhibit 1 through 4?
Yes.
And in fact, having watched and reviewed these, did you initial all of these so that you would recognize these 4 discs contained in package number 5?
Yes.
They're fair and accurate recordings of your testimony to Detective Mays in support of these warrants?
Yes.
Under States 5.
No objection, Your Honor. I believe these are all certified documents provided by the magistrate court.
So admitted.
Looking at States Exhibit 1 through 4 from June 18th of 2014, what was the basis articulated in sum for the court in support of these search warrants for the home, the vehicle, and the iPhone?
And basis, it was laid out the, basically, he got up that morning, took the child to Chick-fil-A, ate breakfast, did not take him to daycare, took him to work, and then left work later that day, seeing the child and pulling over, left work and then realized the child was still in the vehicle, pulled over, and we had the scene at the Matteo's where he gets out of the vehicle and pulls the kid from the vehicle and states, "Oh my God, what have I done?" While the interviews were going on, I was given some information by the detectives watching that regarding statements that were made during the interview, which was added to the second search warrant regarding electronics, was stated they recently searched the internet, child deaths inside vehicles, and temperatures that would occur. I also stated this could be his greatest fear. During oral testimony, I also added that there was very limited or no emotion from Mr. Harris and Mrs. Harris regarding the loss of their son.
Did you also articulate for the magistrate court that this was a homicide investigation involving child neglect?
Yes, sir, I did.
At the time of the issuance of these first search warrants, the charges that you articulated in the 4 of them in total, did they include homicide/murder?
Yes.
And what about cruelty? What degree of cruelty was issued at this?
For this 4 of cruelty, the child in the first degree was listed on all 4.
And can you articulate for the court, at the time of the issuance of these first 4 search warrants, had an autopsy been performed on Cooper Harris yet?
No.
And why then did you seek the warrants based on cruelty in the first degree as opposed to cruelty in the second degree?
When we were going, after the autopsy, they said it was hyperthermia, and we were going by lack of substance, which was listed as cruelty the first.
So at the time of the issue of these, you thought it was a cruelty first, deprivation of necessary sustenance?
Yes.
At some point with these successive search warrants, did that charge change based on information you received from the Cobb County Medical Examiner's office?
Yes, it did.
And once you realized this was hyperthermia versus deprivation of necessary sustenance, did you include those charges in later search warrants?
Yes, later on it was changed to cruelty in the second.
Regardless, for these first 4 search warrants, did you specifically mention to Judge Mays that this was going to be a homicide investigation?
Yes, I did.
Now, I want to talk about items that you were searching for. In your testimony and in the affidavit and search warrant, did you indicate to the court that you would be seeking evidence of child neglect and child abuse?
Yes.
Did that include evidence that you were seeking in terms of electronic or documentary records?
Yes.
When you were speaking to Magistrate Court Judge Mays, did you indicate to him in your oral testimony as a basis for these search warrants that you wanted to try to find out a timeline based on what the defendant had asserted to Detective Stoddard?
Yes.
And what specifically, can you articulate for the court, was it that you were looking for that might assist you with looking into a timeline?
I believe that was brought up during the search warrant for the cell phone regarding gaining information about text messages, phone calls, that type of nature, for basically that day to see what was going on while his child was dying inside the vehicle.
You had also just mentioned child neglect. Were you also looking for anything on his phone and any of these other items that might indicate to you a lack of attention in terms of dealing with his child?
Yes.
And did you mention to the court during your testimony, included in State's Exhibit Number 5, the demeanor of the defendant and his wife during the course of the investigation as being a factor for the issuance of the search warrants?
Yes.
Did you articulate for the court what specifically did you share with Judge Mays?
I said that they're not showing much emotion regarding their child passing away.
You've had an opportunity to look at defendant's motion to suppress filed on December 4th of last week. Is that accurate?
Yes, sir.
Can you first explain in terms of State's Exhibit Number 1 and Number 2, that would be 0596 and 0597, why the difference? Why do we have two search warrants for defendant's home here?
Originally, the first search warrant, we did not have the statement by the defendant, and we were merely searching. The electronic devices were not included in that search warrant.
Based on the statement that was obtained from the defendant, what, if anything, changed in terms of expanding the scope of the search of defendant's home for 0597?
Based on his statement about doing research on in-car deaths and that type of thing, we expanded to include electronic devices to confirm or deny if he had been doing this research and also see when he had been doing it.
0598, or State's Exhibit Number 3, is going to be the search warrant for the vehicle. Is that correct?
Yes, sir.
And what specifically were you looking for in the vehicle that was the basis for that search warrant that was obtained?
For that search warrant, we were looking for trace evidence, including but not limited to latent impressions, hairs, fibers, fingerprints, blood, DNA, the child car seat, cell phones, to photograph the vehicle, take measurements of the vehicle, computers, electronic communication devices, data storage devices that would be located inside the vehicle, or any paperwork or writing related to the crime of homicide or cruelty to children.
Did that search warrant authorize you to seize, among other things, electronic devices that were inside the vehicle in question?
Yes.
And the search warrants that you obtained from the outset in this case, did they also authorize the examination of these items, particularly the electronic devices, for evidence that you referenced to the court?
Yes. After we secured the items, we took additional search warrants to search the electronics.
And I want to look at search warrant 0599, which would be State's Exhibit Number 4. Do you have that in front of you?
Yes.
0599, the search warrant for the cell phone. Did that authorize you to do a forensic examination of the phone for, among other things, to find out call detail and messaging that was occurring?
Yes.
And you requested that both in writing as well as in your oral testimony to Detective Mays, is that correct?
In writing, we physically examined, documented the storage device, forensically imaged or copied, and later examined for evidence of these crimes. And in my oral testimony, I noted the texting and phone calls.
the defense in their motion to suppress pointed out something regarding State's Exhibit number 3 and number 4. Looking at number 3, first of all, what was the offense that was listed on the actual affidavit and application?
Homicide, murder,
And what about on State's Exhibit number 4, what was the offense that was listed there?
cruelty to children in the first degree.
In the body of the application for both of these, did you include that this was a homicide investigation and also involving cruelty for both of these search warrants?
In the affidavit, it was described as a homicide investigation.
Okay. So while it's not specifically listed here as homicide, for example, in State's Exhibit number 4, that is listed in the body of that same document, is correct?
Yes, it is.
And similarly, State's Exhibit number 3, which lists homicide.
I don't think it's cruelty is listed in the body, but it's in my oral testimony.
Okay. So you did provide that either in writing or oral testimony to the magistrate court in support of States 3 and 4?
Yes.
And it was the same magistrate judge for all 4 of these search warrants?
Yes.
The fact that we only have one charge listed on States 3 or 4, was that intentional or was that a mere omission on your part?
This is a mission on my part.
Judge, excessively, there's some leeway here, but I think I'll get to the state lead.
I'll chime with the lead.
I think you can lead a little till you get to substantive, and then certainly when you get into substantive areas, leading would be inappropriate.
Yes, ma'am.
I think so far, we've been all right. I think perhaps Mr. Lupkin was sensing that we're getting to more substantive areas. But I can't speak for him. I'm just guessing.
All right. I want to talk next about the next search warrants that you sought and obtained in this case. What was the date of the next series of search warrants that you sought and obtained?
6/19/2014.
That would be June the 19th of 14, correct?
Yes.
I'm asking you to use that microphone, so I'm having a hard time hearing you.
Sorry.
That's all right. Okay. My math is correct. Did you obtain 7 warrants on that date in front of a different magistrate court judge? 7 search warrants, that is.
Yes, sir.
And who was the magistrate judge on the 19th, the following day, when you applied for these 7 search warrants?
That was Judge Inman.
Judge Inman. And at the time that you obtained these additional search warrants for the second day, did you have more complete information about the investigation?
I believe for those search warrants, the only thing that was added after the last one from the previous night was some statements from Leanna, Mrs. Harris.
Okay. Looking at these search warrants in totality, let's do this for our record. State's Exhibit number 6, Mr. Lumpkin ends with 0605. Do you recognize this as being a certified copy of a search warrant requested for a Dell Dimension computer recovered from defendant's home?
Yes.
State's Exhibit number 7, certified copy of search warrant ending 0606 for a Google Chromecast device, is that correct?
Yes.
State's Exhibit number 8, certified search warrant ending 0607. Is that a search warrant that was obtained for a MacBook Pro laptop?
Yes.
State's Exhibit number 9, search warrant ending 0608. You recognize that as being a certified copy of a search warrant for a Lenovo T530.
Yes.
State's Exhibit number 10, certified copy of search warrant ending 0609 for an Apple MacBook Pro. You recognize that as being search warrant. You obtained certified copy of it.
Yes.
State's Exhibit number 11, search warrant 0610 or ending 0610. Is that a search warrant for an Apple iPad?
Yes.
And State's Exhibit number 12, this is for an iPhone, search warrant ending 0611. This is for an iPhone from defendant's vehicle, is that correct?
Yes.
Looking at State's Exhibits 6 through 12, these are the copies or the certified copies of the search warrants you obtained on the 19th from Judge Inman.
Yes.
Tender States 6 through 12.
No objection.
Additionally, as with the prior testimony that you gave to Judge Mays for the first 4 search warrants, did you give oral testimony in support of State's Exhibits 6 through 12?
Yes.
And you were provided some discs, and did you have an opportunity to review them in advance of this hearing?
Yes, I did.
I'm going to show you a package marked State's Exhibit 13, which collectively contains 1, 2, 3, 4, 5, 6, 7 discs that are numbered on the white package and correspond to the search warrant 6 through 12. Have you had an opportunity to review States 13, all of these discs that are contained in there?
Yes.
And having done so, were you asked to place your initials once you reviewed these so that you would recognize that these were copies of your sworn testimony before Judge Inman?
Yes.
Fair and accurate recordings of your sworn testimony given in support of States 6 through 12.
Yes.
Tender States 13.
No objection.
As with the search warrants obtained the previous dates, did these search warrants authorize for the examination of the electronic devices that are referenced therein for particular evidence?
Yes.
For each of those search warrants, did you tell the court in writing and orally what the basis for the issuance of those search warrants would be?
Yes.
And what additional fact, other than what you've already articulated for the court and what's contained in the warrants, did you include for these additional search warrants on the 19th?
Additionally, on the 19th, I added that Leanna Harris, child's mother, that she was also questioned and made similar statements regarding research in-car deaths and how it occurs.
The electronic devices that are referenced in this, in the search warrants that are before the court, state exhibits 6 through 12, where will those specific electronic devices recover?
The first 3, the Dell Dimension computer tower, Google Chromecast, and MacBook Pro laptop were recovered from the residence, 1212 Winds Ridge Circle. And items 4 through 7, a Lenovo ThinkPad, Apple MacBook Pro, Apple iPad, and iPhone were recovered from the Hyundai Tucson, the vehicle.
Okay. Were those recovered with the prior search warrants that have already been admitted to the court, the first 4 exhibits? that you obtained on June the 18th?
Yes, they were.
And these additional search warrants, did you ask for permission to have your unit be able to examine them forensically for evidence that would be pertinent to this crime?
Yes.
Did you share with Judge Inman the fact that defendant Harris had been interviewed and made certain admissions about a timeline in this particular case?
Yes.
Similarly, did you ask for any permission to search for any videos?
There would have been any evidence related to research on in-car deaths or child deaths in vehicles.
And articulate for the court why it is specifically that y'all are looking for videos involving in-car deaths or death of children in vehicles?
I'm going to object. I don't believe that was answered to his prior question. He asked a question and he said that they were looking for evidence for research. And Mr. Evans' next question assumed something that's beyond what he just said, so I object to the nature of the question.
I don't think
I don't
it's...
think you have to phrase your questions along those lines. You're fine.
I'm sorry,
The question
what?
is, why is it that you were looking for those types of videos on some of the electronic devices?
Mr. and Mrs. Harris had made statements they had watched videos regarding in-vehicle deaths.
And did you mention in the body of the search warrants and affidavits as well in your oral testimony what types of offenses you are investigating on the 19th?
Yes, homicide, murder, and cruelty to children in the first degree.
For the 19th search warrants, were you aware at the time you obtained those that the defendant had not called 911 as part of this case?
Objection, Your Honor. It's only relevant if he actually disclosed something to the magistrate. What other knowledge he may have, unless of course it's a material omission, which I guess we may get into. If it's irrelevant, any information other than what's actually in this affidavit and in its oral testimony. I think it is an attempt, or maybe not an attempt, but it could confuse the court and the fact finder looking at this to determine what is the actual basis for this search warrant. If something that's outside of that, that'd be a problem.
For what purpose is your question?
Well, it's two purposes. I want to see, one, he knew that information, and the follow-up question, obviously, is did he share it with the magistrate court, or does he recall?
You can do that.
So my first question is, were you aware that he didn't call 911? And then answer that question first, if you will.
We were aware through our dispatch that they hadn't received a phone call from him. At that time, I wasn't specifically sure if he had called or not from his phone, but we did not, from our 911 dispatch center, they said they had not received a phone call from his number.
As part of the first batch of search warrants, State's Exhibit number 4, I believe it is, for the iPhone that was recovered from defendant, did that authorize you to look at the call details to see who, if anyone, had been called from his phone from
Yes.
that day?
Yes.
Okay. I want to talk about your next series of search warrants. Do you recall the date of the next series of search warrants that were obtained?
It'd be June 24th, 2014.
Prior to June the 24th of 2014, did you participate in the examination of any of the devices that were the subject of the first search warrants we talked about?
Prior to that date? No.
Yes. So you didn't, in other words, execute them in terms of an actual search of content on any of these electronic devices?
No.
I want to talk about June 24th of 2014 then. Which judge did you approach in terms of your application for additional search warrants in this case?
That would be Judge Hicks.
Judge Hicks. And can you please articulate for the court why it is that you sought additional search warrants, some of which included devices and things that had already been recovered and were the subject of previous search warrants? What had changed?
We had received additional information through the investigation and wanted to be more detailed on what we were searching for.
What is some of the additional information that you had by the time of June the 24th of 2014?
We had information. We knew through the initial interview that Mr. Harris had gone to lunch with his two friends, but we did not know that he had returned to his vehicle during the issuance of the first group of search warrants.
How were you able to find out prior to June 24th of 2014 that the defendant had returned to his vehicle about midday, the date of Cooper Harris's death?
Through the surveillance video from Home Depot.
And reviewing that Home Depot video review, was the defendant observed returning to his vehicle sometime around lunch?
Yes.
Had the defendant said anything during his interview with Detective Stoddard about that fact?
No, he did not.
Did you include that as part of the additional basis for the search warrant on the 24th?
Yes.
What about the medical examiner? Did you have any additional information by June 24th of 2014 from the medical examiner that became a basis for these search warrants?
Yes, they said the death was caused by hyperthermia.
Hypothermia as opposed to...
Sustenance,
okay.
or lack of sustenance.
Because of that, the subject line or the offense that you're investigating, did you change what was listed on the search warrants that were obtained on June 24th of 2014?
Yes, it was changed to cruelty to child in the second degree and homicide murder.
So still
So it's still homicide, but cruelty in the first was changed to cruelty in the second.
In addition to that, did you provide more precise, detailed statements about what the defendant had told Detective Stoddard during his interview?
Yes, I did. We were able to more review the video, and also I was able to discuss with Detective Stoddard in more detail what was discussed in the interview, which was added to this. And we got the statement was a little more detailed. It said during the interview, Harris stated leaving the son in a hot car was the biggest fear. According to Harris, he recently viewed a television show concerning child death in cars. Harris also stated that he researched issues of death in cars on the internet.
Okay.
Instead of having one sentence with it all together, it was separated more.
You broke that down into separate sentences for the 24th?
Yes. He also made statements knowing specifics on the car seat during the interview, what the weight limit was and stuff like that. So we're looking at searches for car seats. And he claimed that he was happily married. Nonetheless, evidence of inappropriate sexual communications with other women was obtained.
So prior to the 24th, you had received information that despite defendant's claim, there was some infidelity.
Yes.
Did you include that as a basis for your written search warrants as well as your oral testimony that you were looking for evidence of motive and marital disharmony?
Yes.
What other things did you include in your application for search warrants on the 24th involving defendant's assertion about happy marriage? Did you include in there? What other things were you looking for?
We're also looking for videos, photos of the child to show development. Was he developmentally where a 22-month-old should be? Also, we still had searches regarding in-car deaths, communications with other people leading up to, including the day of the incident. This isn't just happening on cell phones now. There's different messaging, Kik and other type of messaging services you do over the internet and on computers. Statements were made regarding life insurance policies. We were looking to see if he had a life insurance policy on the child and what that would have been.
What information did you have that led you to include that as a basis for search warrants?
I believe that information was obtained through jail phone calls, I'm not for sure.
And let me show you the actual search warrants from the 24th, certified copies. State's Exhibit number 14, certified copy of search warrant ending 0633. Do you recognize this as being the search warrant for the Dell computer that was the subject matter of a prior search warrant?
Yes.
State's Exhibit number 15, search warrant ending 0634. You recognize that as being a search warrant for a Google Chromecast device that was the subject matter of a prior search warrant?
Yes.
State's Exhibit number 16, certified copy of search warrant ending 0635. Search warrant for MacBook Pro, subject matter of previous search warrant, correct?
Yes.
State's Exhibit number 17, certified copy of search warrant ending 0636. This is for a Lenovo T530 ThinkPad from a vehicle.
Yes.
I'm sorry, did you say state 17?
17, and it's 0636.
Was there 16?
Yeah, 16 is 0635.
Okay.
Confirm that for me for the record. I may not have said the exhibit sticker.
Yes.
Step up there, Judge, just to verify that.
Of course you know.
I got off kilter.
That's fine. Let me just back up to make sure I didn't mess it up. Maybe that'll assist you.
Thank you.
Okay. So 14 is 0633, correct?
Yes.
15 is 0634.
Yes.
16, certified copy of 0635.
Yes.
17, certified copy of 0636. This
Yes.
for a Lenovo and a vehicle as well, correct?
Yes.
18, certified copy of 0637 for an Apple MacBook.
Yes.
18, certified copy of search warrant ending 0638 for an iPad. Is that correct?
Yes.
Sorry, what number is that, Travis?
0638, number 19.
19. Thank you.
State's Exhibit number 20, 0639 for iPhone from vehicle,
Yes.
subject of a previous search warrant. Is that correct?
Yes.
21 is a certified copy of a search warrant for defendant's home. Is that correct?
Yes.
And finally, State's Exhibit 22, certified copy of search warrant 0641 for defendant's Home Depot HR records. Is that correct?
Yes.
Tender states 14 through 22.
No objection.
As with the testimony to support the prior search warrants that were obtained on the 18th and 19th, did you give oral testimony to Judge
And
Inman?
Hicks? Yeah, Hicks.
Hicks, I apologize. This is packet numbered State's Exhibit 23. For the record, inside 23 are a series of discs. There are 9 discs here, labeled 12 through 20. You had an opportunity to review these discs.
Yes.
And after reviewing, did you initial each one of them to confirm that this is fair and accurate recordings of your oral testimony that was provided to Judge Hicks in support of States Exhibits 14 through 22?
Yes, I did.
Tender States 23.
No objection.
Submitted.
For these additional search warrants obtained on the 24th, did they authorize you and Cobb Police to look into some motive evidence and evidence of marital disharmony?
Yes.
For States Exhibit number 22 specifically, what items were you looking for States Exhibit number 22?
22 is, okay, the HR. Any information on life insurance and also pay stub and finances, that type of thing,
Okay.
go
And
towards motive.
what was the subject of the location of where that search was actually going to be conducted? Was this defendant's home or elsewhere?
Home Depot.
Home Depot. So you were seeking records in possession of Home Depot, his employer?
Yes.
States Exhibit number 21, the additional search warrant for defendant's home. Can you articulate why it is that you wanted to go back into defendant's home and what you and detectives were seeking specifically?
Yes, when the defendant went to lunch, they went to Publix, had some lunch, and then he went to Home Depot and purchased some light bulbs. And when we went back to his vehicle at lunchtime, he put the bag of light bulbs into the vehicle.
Is that what was observed on the Home Depot video footage?
Yes, based on the footage and also the search of the vehicle, the light bulbs being located in there. And we wanted to search his residence to confirm did he have a reason and need to purchase light bulbs, or was this just a reason to have his two friends drop him off at the car and to get in the vehicle? It's basically an excuse to get in the car.
The first three search warrants for Dell, the Google Chromecast device, and the MacBook Pro, where were those items of evidence actually recovered from prior to the issuance of these additional search warrants?
First three were recovered from the home.
And what about the Lenovo, which is the subject matter of 0636? Where was that recovered?
From his vehicle.
And what about the Apple MacBook 0637?
From the vehicle.
How about the iPad and iPhone, the subject matter of 0638 and 0639?
Also the vehicle.
For these additional search warrants, did you share with Judge Hicks in writing or otherwise that you had learned the defendant had been messaging other women on the date of Cooper Harris's death?
Yes, I did.
And did you specify authorization to confirm some of those messaging, either by text message or otherwise, from defendant with these other people?
Yes.
All right, I want to talk about your next set of search warrants. Did you seek additional search warrants a few days later from a different magistrate court?
Yes, sir, I did.
Excuse me, different magistrate court judge, I should say.
Different judge.
And what was the date of the next search warrants that you obtained?
June 27th, 2014.
All right. Now, what were the specific items that were the subject matter of the June 27th, 2014 additional search warrants?
We were looking at a SanDisk Cruise Glider thumb drive, external hard drive, my passport external hard drive, SanDisk SD card, a DVD-R, We also had an additional search warrant for Justin Harris's residence. And then one search warrant for Cooper Harris and Justice Harris medical records from Kaiser Permanente. And a search warrant for Justin Harris's cell phone, and that would be the one he had on his person the day of the incident.
So we're clear for our record, there's two different cell phones that were recovered on June 18th, is that correct?
Yes.
This second search warrant that was obtained, we'll get to the number in a second, on the 27th, that was for the initial cell phone that was recovered by Piper, is that correct?
Yes.
Let me show you these additional search warrants. And I'll go slowly for our record. State's Exhibit number 24, search warrant ending 0653 for scan disk recovered from vehicle. Does that look accurate?
Yes.
State's Exhibit 25, search warrant ending 0654, external hard drive. Is that correct?
Yes.
State's Exhibit 26, search warrant ending 0655, search warrant for a scan disk 2 gigabyte SD card.
Yes.
State's Exhibit 27, search warrant ending 0656, search warrant for a DVD-R.
Yes.
State's Exhibit 28, search warrant ending 0657, subject matter being defendant's home. Is that correct?
Yes.
State's Exhibit 29, search warrant ending 0658, search warrant for Kaiser Permanente records of deceased victim Cooper Harris. Is that correct?
Yes.
Similarly, State's Exhibit number 30, search warrant ending 0659, search warrant for Kaiser Permanente records, this time of defendant Ross Harris, correct?
Yes.
And then State's Exhibit number 31, a subsequent search warrant ending 0660 for the iPhone 5 recovered from defendant on June the 18th of 2014.
Yes.
All right. Tender States 24 through 31.
No objection.
So moved.
As with your prior search warrant applications, did you on the 27th give oral testimony to Judge Philip Taylor?
Yes.
I'm going to show you, then marked as package State's Exhibit number 32 containing seven discs which have numbers 21 through 28 and corresponding search warrant numbers. You've seen these discs, is that correct?
Yes, I have.
And having looked at them, did you initial the discs after reviewing them to confirm that they fairly and accurately contain the sworn testimony you provided to Judge Taylor in support of the search warrants, State's Exhibits 24 through 31?
Yes.
Tender States 32.
No objection.
So moved.
Mr. Evans?
Yep.
Just double check again, and I apologize if I'm just not tracking. I'm noting there's 8 search warrants there from 24 to 31. Are there only 7 discs, or there are
There are 8 search warrants, and there are 8 disks in State's Exhibit 32.
Very good, thank you. Hey, thank you. No good.
Admitted without objection.
The scan disk that's the subject of search warrant 0653, where was that specifically recovered?
From the vehicle.
What about the external hard drive that's the subject matter of 0654? Where was that external hard drive recovered?
Also the vehicle.
How about the scan disk 2 gigabyte SD card that's the subject matter of search warrant ending 0655? Where was that recovered?
Vehicle.
(0656), the DVD-R that you received a search warrant for, where was that recovered?
Vehicle.
State's Exhibit 0657, what was the subject matter of that particular search warrant?
To search this, Mr. Harris's residence.
And did this expand the scope of the permissible search of his residence from the prior search warrants?
Yes, it did.
And explain, please, for the court.
We also included, just like the previous one for the residents, included the light bulbs, but we were also looking for any financial paperwork, banking information, credit card information, life insurance policies, or business paperwork, or related items to that.
For State's Exhibits 29 and 30, search warrants ending 0658 and 0659, what was the target or entity from which you were seeking documents in those 2 search warrants?
Kaiser Permanente.
So a third party, not from the defendant's home or vehicle or anything like that.
Correct.
And then State's Exhibit number 31, what's the target or subject matter of this particular search warrant?
It's the Mr. Harris's iPhone, which was on his person the day of the incident.
And did specifically State's Exhibit 31, did you seek authorization to expand the scope of what you were looking for on that iPhone based on newly discovered evidence from the investigation?
Yes, I did.
Can you please explain to the court?
We, in addition to, I think the original warrant, search warrant was just for regarding his statements about researching in-vehicle deaths. So we also included text messages, phone calls, and communications the day of the incident and leading up to. For this one, we included, because iPhones, you have internet access, and there's more capabilities than previously with older phones. Finances, credit card debt, business information, life insurance policy information, emails or communications about the child, wife, or family issues, photo videos of the child to show development, any research on information on car seats or information on car seat searches. Of course, we had searches about in-car deaths and communications with others on the incident date or days leading up to the incident.
And that include people that he may have been having extramarital affairs with?
Yes.
And had you learned that information prior to obtaining these search warrants from June the 27th?
Yes.
about some additional search warrants that you obtained in this case in August of 2014. Did you seek and obtain a couple of additional search warrants in the case?
Yes, I did. On August 14th, 2014, I obtained an additional search warrant. And this was for a Lenovo ThinkPad model T510. I believe Home Depot had contacted us and said that they had, Mr. Harris was issued a new computer in March of 2014, and they had the old one in storage. So this would have been the computer he had prior to March 2014.
Okay. Before I leave the 27th and we talk about that specific search warrant, in case I neglected to ask, for Judge Taylor, did you specifically incorporate all of your sworn testimony for all of those search warrants from the 27th to be included as a basis for all of them?
Yes.
For the August 14th, 2014, which judge did you apply for this additional search warrant?
Was Judge Strauss.
Okay. And I'm going to show you State's Exhibit number 33. State's Exhibit number 33 is search warrant ending 0816. Is this the certified copy of the search warrant you just referenced for a Lenovo ThinkPad that was in the possession of Home Depot corporate office?
Yes.
And I think you referred to it as defendant's work computer, is that correct?
Yes.
Tender States 33.
No objection.
Admitted.
This is State's Exhibit 34, which is a single disc. Looking at this single disc, did you have an opportunity to review it to confirm that this contains your sworn oral testimony that was provided to Judge Strauss as the basis for search warrant number 33?
Yes.
Okay. Tender States 34.
No objection.
Admitted.
The subject matter of this particular search warrant from August the 14th, where specifically was that property located that you were seeking to obtain?
At Home Depot.
This was not in the defendant's residence or in his vehicle or anything like that?
No.
And whose property was it that you were seeking to obtain? Who actually owned that property?
Home Depot.
What was the next date for the final search warrant that you obtained in this particular case?
That was August 19th, 2014.
And what was the subject matter of that additional search warrant from August 19th of 2014?
That was to obtain the electronically stored data in the Lenovo ThinkPad T510 that the previous search warrant was for. This was to include finances, credit card debt, business info, life insurance, emails, communications regarding child, wife, and family issues, photos, videos of child, to show development, information about car seat searches, searches regarding in-car deaths, information on life insurance policies, and any other information related to the incident.
This is State's Exhibit number 35, certified copy of search warrant ending 0844. Is that a copy of that August the 19th search warrant that you had just given some testimony about?
Yes.
And who was the judge for this August 19th, 2014 search warrant that you obtained?
It was Judge Inman.
Tender States 35.
No objection.
Admitted.
As with the prior search warrants, you gave oral testimony in this case?
Yes.
Looking at State's Exhibit 36, this single disc, do you recognize this as being a fair and accurate copy of the oral testimony that you provided to Judge Inman in support of search warrant 0844, State's Exhibit number 35?
Yes.
Tender States 36.
No objection.
Admitted.
what, if any device in this particular case, did you actually conduct a search of, or in other words, did you actually examine? Did you look at any of the electronic devices, or was that tasked to somebody else?
I had looked at one computer.
And whose computer was that you looked at?
Was the Apple MacBook Pro.
For all of the items that were the subject matter of all of the search warrants that have been provided to the court, all of those items were within the jurisdiction of Cobb County, is that correct?
Yes.
I think that's all I have, Judge, at this time.
We talked examination, I expect to be more than 2 minutes.
I think so, Judge.
Let's recess until 1:15. Everybody have a good lunch.